Welcome back. You're watching the cases of Malmo-Levine, Caine, and Clay versus Her Majesty the Queen.
Justices of the Supreme Court of Canada, my name is David Malmo-Levine. I consider myself a justice and freedom activist. I am part of a growing number of such activists who view cannabis re-legalization as a key part of protecting human rights and our Mother Earth, while at the same time helping to end war and poverty. As you can see, I'm not a lawyer. I am, however, a cannabis user and a researcher, and I would like very much once again to be a cannabis retailer and perhaps grow a few plants. My case differs from the others in that I'm here primarily to articulate the rights of cannabis users and growers and retailers under both Section 7 and Section 15 of the Constitution. I wish to use the evidence of harm reduction found in Caine and Malmo-Levine to shift the debate from whether cannabis's harms are trivial to whether cannabis's harms are mitigatable, for lack of a better term. I will keep my focus to the court's jurisdiction, to the unconstitutionality of decriminalization, to harm reduction and its relation to the harm principle, and to autonomy, the burden of proof, equality, and monopoly. But first, a little bit about the Harm Reduction Club, the group of about 1,800 people in Vancouver who helped me to get here before you. Turning to page 1 of my factum, under adjudicative facts, on page 1 you will see a brief description of the Harm Reduction Club, a club which was created to educate users and the general public about marijuana and to provide unadulterated marijuana to its users at club cost. Lower down on that page, you can see that even Sergeant Dion, the police's expert on marijuana, felt we, quote, offered methods to reduce the harm from any more marijuana use, unquote, and that we were a, quote, consumer-oriented venture, unquote, following a, quote, well-established cultural tradition, unquote, of cannabis smoking in Vancouver. Notice how both my parents and my apartment manager testified to their support of the club. In my submission, the evidence of harm reduction methods recognized as such by the police's cannabis expert, aside from the evidence of cultural traditions and community support, is enough to warrant Section 7 protection. John Stuart Mill would not have approved of the idea of fines or any other punishment for cannabis crimes. If I can direct you to my Book of Authorities, tab 14, page 13, Mill said he was not only against the compelling of someone to do something for their own good. Mill was also against, quote, visiting him with any evil in case they do otherwise. In my submission, fines for harmless behaviors are exactly the type of evil Mill was referring to. Found in Mill's On Liberty, specifically the second half of page 15 at tab 14 of this appellant's Book of Authorities, exists a list of political rights found in our Constitution: thought, belief, opinion, expression, association, assembly. In the very same paragraph, Mill spoke of our non-political rights, our rights to tastes and pursuits, the right to do any harmless activity, alone or in groups. In my submission, to be true to the liberty found in our Constitution, a liberty founded on Mill, we need our political liberties, but we also need our medical liberty and our personal autonomy, our orientations, our hobbies, our tastes, and our pursuits. Jumping back to page 5 of this appellant's factum, you can see the one key fact that came out of my trial that the appellant wishes to stress. Quote, there in fact are no harmful effects of marijuana on others or society that can't be reduced in some way through reasonable regulation. That's in my Book of Appeals, Volume 1, page 106 and page 186. In my respectful submission, the fact that all harms are mitigatable is very, very important to recognize. This appellant has been denied his right to call experts in exchange for having that fact recognized. This court must not use the excuse that you can't begin to discuss dealing until you are done looking at possession, as the lower courts have done, To see the harm reduction evidence ignored again and again, it feels like an unfair trial. In my submission, evidence of cannabis harm reduction is ignored in Canadian courts in much the same way as medical marijuana is ignored in American courts. Because the moment this court recognizes the existence of cannabis harm reduction, then by virtue of the harm principle being a part of Section 7 and arguably Section 15 as well, the growing, dealing, and using of marijuana become protected activities. Because these activities are harmless when done properly. There is plenty of evidence before this court of cannabis harm reduction. Let us now review this evidence. Turning to pages 8 to 10 of this appellant's factum. In Stockdale versus Hansard, Lord Denman repeated the ancient Latin maxim that, quote, no valid conclusion as to the use of a thing can be drawn from its abuse. In On Liberty, John Stuart Mill wrote, quote, the class of dealers in strong drinks, though interested in their abuse, are indispensably required for the sake of their legitimate use. And notice that that last quote had tied the harm principle and dealing drinks, but dealing drugs together. Arab doctors of the 12th century advised that eating cannabis helps against sorrow if you eat a little. The 16th century Chinese master herbalist Li Shisen explained that, quote, hallucinations and an unsteady gait come through the immoderate use of cannabis. And see also this appellant's Book of Authorities, Volume 1, tab 19, for one of those references, the others in my factum. Casanova once said, in wise hands, poison is medicine, and in foolish hands, medicine is poison. Now, this is true of cannabis even more so than any other drug, because cannabis makes a lousy poison, very difficult, if not impossible, to kill yourself with through overdose. More recently still, the 1997 World Health Organization report on cannabis pointed to dose, mode of administration, psychological and pharmacological differences, complexity of performance tasks, situational demands during testing, and prior drug experience of the subject as factors involved in proper cannabis use. As can be found in this appellant's speech to the trial judge, supplemental record page 8788, I testified that harm reduction meant education, quality control, and a safe point of sale. I testified that education meant teaching about the hazards of prohibition, but also about smarter smoking methods, and that smarter smoking meant focusing on the following factors: dose, mindset, setting, strain, quality, potency, smoke cooling, clean ignition, and clean mode of administration. We at the Harm Reduction Club taught users how to look for signs of chemical fertilizers and pesticides, or mold, or other contaminants that may cause them respiratory illness. Dr. Morgan, one of the experts in Caine, defines harm reduction as, quote, helping drug users minimize the dangers to themselves without mandating that they stop using drugs. In Caine, Dr. Burstein, Dr. Morgan, Dr. Connolly, and Dr. Callant all testified to the existence of cannabis harm reduction. Dr. Morgan, Dr. Connolly, and Dr. Callant testified that impairment was primarily dose-related. Dr. Burstein and Dr. Connolly both testified that risk from smoke can be mitigated in some way, with Dr. Morgan suggesting very wisely that smoking less volume of more potent cannabis, given the non-toxic nature of the cannabinoids and given the universal tendency to self-titrate, would result in less heated plant matter per dose and as a result less stress on the lungs. Not that there's much to begin with. These harm reduction bits of evidence are found at the trial transcripts in Caine for Dr. Burstein on November 27, 1995, for Dr. Morgan on January 27, 1997, for Dr. Connolly, January 27, 1997, and Dr. Callant, January 31, 1997. In her decision in Caine, Her Honor Judge Howard wrote, naive users should be careful if they choose to smoke, should do so with experienced users and in an appropriate setting. Justice Braidwood quotes Justice Howard in Caine where she pointed out that it is the prohibition of marijuana that creates an artificial, quote, lack of governmental control over the quality of the drug on the market, unquote. Justice Braidwood mentions the We Met report and its recommendations that, quote, no conduct should be defined as criminal unless it represents a serious threat to society and unless the acts cannot be dealt with through other social or legal means. Justice Braidwood then quotes two other reports, the Law Reform Commission report and the Criminal Law in Canadian Society report, which say more or less the same thing. And at this point, I would like to direct you to Mr. Conroy's arguments regarding state interests and overbreadth, as I believe this is an extension of the We Met argument of that these matters can be addressed through other means. These concerns, these legitimate concerns of society, can be addressed other ways. Highlighting the role of education in cannabis harm reduction, the 1991 judgment of the German Regional Court, heretofore called the Lübeck decision, stated, in view of the relatively limited dangers of cannabis products involved, a suitable program of education and information is sufficient to deal with them, and in a less drastic measure. In my submission, the above dozen or so quotes regarding cannabis harm reduction should be enough to convince any reasonable person of its existence. These quotes are enough evidence to end the debate over whether the harms that may come with cannabis are significant or trivial. In my submission, the harms that may come with cannabis are, if anything, mitigatable, and they are mitigatable to well below the level of the trivial. If we choose to look at cannabis use without understanding the difference between black market use and proper use in a regulated market, we risk once again assessing cannabis harms incorrectly, basing our conclusions only on the effects of unregulated distribution and uneducated use. If re-legalized, cannabis could once again be re-regulated to mitigate harm. According to Emily Murphy, Canada's first prohibitionist, cannabis is like a flame from a black candle. And we are all moths, undeniably drawn to it, destined to be burned by it. But many others see cannabis differently, not as a crime or a vice or a sin. Even if you reject this appellant's evidence on tab 22 in his book of authorities regarding the time-slow performance-enhancing effects, or Mr. Arve's evidence mentioned on page 7 of the BCCLA factum, that it is a medicine used by healthy people for thousands of years for heightened awareness, or Dr. Connolly's testimony given on the 27th of January 1997 that cannabis is a performance enhancer for the young, you must admit from all the reports all over the world, including those mentioned at tab 19 of my book of authorities, that cannabis is a substance associated with relaxation and euphoria. And these are good things in and of themselves. We're allowed to use other herbs, even prescription drugs, for these purposes. Why not cannabis? The cannabis plant is not sinful, not evil, and while it is not inherently harmless, neither is it inherently harmful, or even relatively harmful. Like all plants, cannabis is a tool we can all easily learn to use properly. As it is confirmed in the evidence found in all three challenges, cannabis is a tool for stress, depression, and fatigue, loss of appetite, lack of sleep, or motivation or inspiration or focus. And in my submission, it is time the human race evolved to accommodate our innate natural tendency to self-medicate with herbs for minor, day-to-day preventative medicine and performance enhancement reasons. We allow the same self-medication autonomy for another soft drug, caffeine. Why not cannabis? In Caine, Dr. Morgan testified that cannabis was less addicting than caffeine, pointing out cannabis was considered among the safest therapeutic agents known. Dr. Morgan also described the cannabis cafes in Holland as, quote, civilized and polite. Dr. Peck pointed out that even heavy users of cannabis do not drain society.